Hello, everyone. Thank you, Kelly. For those not familiar with me, as Kelly said, Matt Rich with MidPenn Legal Services in the Harrisburg office. I practice primarily in the area of housing, also do some utility work as well. The purpose of today's session is to cover issues that we've identified or are easily identifiable when dealing with remote hearings. Which of course have seen an increase in use by the court system and different judges' offices throughout the state as a result of COVID-19. This was brought about by the Planned Housing Law Group having kind of piqued an interest in issues surrounding the use of advanced communication technologies by the court system and trying to identify instances where we might be able to work with our clients in helping them deal with the catch-22 situation created by COVID-19 and hearings before magisterial district judges or in courts of common pleas. So, as I'm sure I don't have to explain to you folks, generally the issue is this, rock and a hard place type situation where on one hand, our client population in many instances may not be able to attend in-person hearings during this time, either because they have pre-existing conditions, if they're elderly or disabled, or if they are single parents who lack appropriate child care, lack of transportation, all of the issues that you all are surely aware of. But then also at the same time trying to balance that against the court's use of advanced communication technology and how for folks of lower income or lesser means, it may be very difficult for them to be able to connect with any advanced communication technology, whatever platform it is, whether it be Zoom or Windstream is a big one in our area, or Microsoft Teams, WebEx, whatever it might be, not having the means by which to potentially connect. Even if they wanted to, and even if they can connect because they have the technology, trying to figure out the technology and utilize that appropriately. And in the context of that, being able to participate in their pending lawsuit. And so we're fortunate today to have with us the Director of Litigation for the National Housing Law Project, Eric Dunn, who is a national expert in housing generally. I've found Eric to basically be unbelievably knowledgeable in almost every facet of housing cases over the years in his work with NHLP. The National Housing Law Project is based in San Francisco, but also has an office in DC, and they have advocates throughout the country. Eric himself is in Richmond, Virginia. They are for housing advocates. They are the go-to nationally for information, for guidance with regard to dealing with housing issues, and they've been vital in helping us through much of the disarray that has come from COVID-19. So I'm going to turn it over to Eric here in a second. Eric is going to lead us through his PowerPoint slides here on identifying issues related to, and this is geared towards primarily stopping evictions and housing issues in particular. That said, I think that you'll find that many of the issues which Eric is going to touch on will likely translate to other areas of law. And then later, sometime in here, we're going to also try to fit in a couple of case examples of individuals, or at least one individual in particular, who has actually participated in a remote hearing through the local magisterial district court. So at this time, I'm going to turn it over to you, Eric. Eric, thank you very much for joining us. And this is Eric Dunn, ladies and gentlemen. Thank you.
Thanks, Matt. Before we get straight to the remote hearings aspect, a little trouble advancing my slides here. Okay, there it is. You may have heard about the looming eviction crisis, the mass eviction crisis that the United States is facing, could be facing again. Usually people have been using different types of natural disaster terms to refer to it. tsunami, avalanche, wave, whatever it is, the numbers are really staggering. Different estimates have put the number somewhere between about 19 million at the low bound and close to 30 million at the high bound. These are households that would be evicted. In terms of actual individuals, I've seen the number as high as 43 million individuals that could be evicted. To put that into perspective, there's about 42.9 million renter households in the country. So if you have more than 20 million evictions, you're talking about close to half of renter households being displaced. The U.S. population, of course, is about 340 million. So you're talking about 10% of the U.S. population potentially at risk. A lot of these numbers you see here are projections, but the U.S. Census Bureau survey has been actually surveying people, and they estimate about 10 million people are already delinquent in rent. Another 30 million have some degree of concern that they won't be able to make their next payment. So, we're looking at evictions on really an incomprehensible scale. In a typical calendar year, there's between about 700,000 and 1 million residential evictions in the country over the entire year. These numbers could take place within a matter of a couple of months if they were to go forward. And of course, you're looking at numbers 20 and 30 times what we normally see. And so part of this is this is really part of the impetus for courts to be looking at ways of being able to hold hearings remotely, because while as housing advocates, we're looking at this in terms of the human impact, the impact on communities, all the harms that come with evictions. A lot of courts are just looking at their case numbers and their backlogs, and they're saying, we're going to have even more to deal with. We can't afford to be sitting around not hearing these cases in some way, shape, or form. So that's unfortunately one of the sources of pressure on courts to be moving forward with evictions, however they can figure out how to do it. So, of course, we haven't seen evictions on this scale happen just yet. That's partly due to a number of state and local eviction moratorium that were put in place. Then, of course, we had the national moratorium on a number of cases with the Federal CARES Act. We still have the 30-day notice requirement that Act imposed on covered properties. The CARES Act also prohibited late fees, and so late fees that were charged during that period remain unlawful. That remains an issue that makes handling non-payment cases at this point more complicated than it was in the past. And then, of course, the CARES Act was not extended. There was no new congressional action to put in a new moratorium to replace the CARES Act. But on September 4th, the CDC published its temporary halt on evictions, which I'm sure many of you are familiar with. Of course, we have had lots of evictions going forward, but it's helpful to understand that a lot of these are some of them are sort of traditional non-payment of rent evictions, but a lot of them fall into different gaps where state and local moratoria didn't cover. There were evictions for criminal activity, there were evictions for lease violations, things of that nature. So they may have had factual issues, a need for testimony and things in those cases, which you may not always have if it's just a non-payment of rent case and the tenant agrees they didn't pay the rent. There's no dispute as to how much was owed. Where you don't have the same kind of need for evidentiary findings and weighing credibility as you will in a behavioral non-payment case, or maybe a situation where the landlord is finding some kind of pretextual basis to pursue an eviction because they know they're not allowed to use a non-payment case or something, and the tenant is contesting that. So I think one of the concerns for using remote hearings is that there may be sort of an expectation that, well, most of these cases are non-payment of rent. There's not really factual issues in dispute. That's not necessarily true of the types of evictions that are going forward under the current conditions. Other considerations with some of the moratoria, for instance, tenants needed to present different documentation requirements. In some states, for instance, showing that they had an income loss related to COVID-19, landlord may be saying, well, you may have lost your job, but you just got fired. It didn't have anything to do with COVID-19, and now there's a factual dispute. So really, I think there are significant differences in the way that eviction cases that are going forward, the different types of issues and different types of court practices necessary to process those cases. And that's something to keep in mind when we get into talking about the remote hearings. The CARES Act in particular, I think as any advocates who handled cases during the CARES Act moratorium are well aware, that was a very complicated law. It was very difficult to figure out in some cases whether tenants were covered or not. In some cases, the only source of that information may have been the landlord, who may not have been forthcoming with information about the financing or different types of programs they may have participated in, and so forth. There were some ambiguities in the text as far as what types of notices could be given, what types of eviction cases could be filed. Certainly, bias text applied to non-payment of rent cases, but did it also apply, say, to lease expiration cases where the reason the landlord didn't renew the lease was because the tenant was delinquent in rent? That wasn't clear from the text. So again, the CARES Act making eviction cases much more complicated in a lot of circumstances than they might normally be. And then, of course, the CDC moratorium is probably even more complicated than the CARES Act provision was. Just some of the obvious causes of complication with the CDC moratorium. It expires on December 31st. So does that mean a landlord may not give a notice to terminate a tenancy until December 31st? Or does it just mean the landlord can give a notice to terminate a tenancy, but the expiration date can't be until after December 31st? Of course, we've seen some states say that landlord can give these termination notice as usual and can even file a case and just can't do the physical eviction before December 31st, which I personally find an absurd reading of the order, but nonetheless, some courts have decided. There are some differences in terms of which properties it applies. It exempts hotels and motels, but does that include a hotel if the tenant has a lease and is living there on a more of a long-term basis? What if it's basically an apartment building that's called a hotel or something like that? There's some room for disagreement on that. Of course, the tenant has to be able to actually provide a declaration to the landlord in order to take advantage of the CDC moratorium. That requires making 5 key statements that some tenants may not be able to make. There may be some disagreement with the landlord as far as whether those things are true. For instance, the tenant is required to make partial payments to the best of their ability based on their circumstances. The tenant decides they can afford to pay $500 a month in rent instead of the full rent of maybe $1,500, and the landlord thinks the tenant can afford $1,000 a month. Is there going to be some kind of a hearing to decide whether that's true or not, or are there procedures that go along with that? So,
Eric, if I could just interject there really quickly on coverage, if you can go back a slide there. So on coverage, just to know here, and for folks on the call here to note for Pennsylvania. So, Eric, our court oversight at the state level is called the Administrative Office of Pennsylvania Courts, so the AOPC. And for those who are not aware, the AOPC has been issuing guidance memos to the court system after the institution of each of the different moratoriums, whether it was through the CARES Act or our governor, Eric, had actually instituted some executive orders that led to the moratorium on the filing of some new cases. And then with the CDC moratorium, they also issued a guidance memo. And one thing that they have in their guidance memo is that they put in big, bold letters that their reading of the CDC order is that it applies solely to cases of non-payment of rent. And so we had been trying to fight with them to get them to change that language to also include end of term cases or the end of lease cases. But they're, at least thus far, been unwilling to change their stance on that in that position. So one thing that I can say for those on the call who are housing advocates throughout the state, if you haven't already run into this problem, you're likely to run into the problem where, especially at the low level courts with the magisterial district judges, you're going to run into a problem where they've been treating that AOPC memo as gospel. And despite our best efforts, we're unlikely to be successful in arguing that the CDC order should apply to end of term cases, at least at the magisterial district court level. So we still feel that the argument is perfectly viable based on what Erica just mentioned. But just know going in that you're likely to be met with resistance at the MDJ level. And to the extent that you want to take on that argument in a case, you're likely going to have to do it by challenging the MDJ judgment through either an appeal or a writ of certiorari to the Court of Common Pleas. So thanks, Eric. Sorry about that.
Thanks for adding that. I did try to actually look at some of the Pennsylvania materials interpreting these things, and there were so many different things and they were complicated that I decided that it would be better if I didn't try to talk about that. But that's unfortunate. I think probably the most persuasive argument I've seen that suggesting that the CDC order should apply to all cases other than the 5 enumerated lease violation situations within the order itself came from Pennsylvania advocate Robert Daimler, who pointed out how the way the order is worded is it says that the subject to the limitations in the applicability section of the order, a landlord shall not evict a tenant or evict a covered person. And then it's where the applicability section is where you find those 5 enumerated grounds for permissible evictions. So it seems like a very convincing text-based argument. So it's particularly disappointing to hear that Pennsylvania, of all states, reached that conclusion. So one reason that we're actually not against remote hearings and think that they actually do play can play a beneficial role in some circumstances and may even be essential for some tenants, is that apart from all the difficulties we've seen in stopping judicial evictions during the COVID era, there's also been a marked increase in illegal extrajudicial self-help type practices by landlords, whether you're talking about changing locks or cutting off utility service or engaging in different kinds of tricks and misinformation to get people to leave or resorting to threats of violence or things like that. It's important for tenants to be able to get into court quickly and have a hearing to have access to premises restored after something like that has happened. A lot of times, especially if courts are not open for in-person hearings, or if the tenant isn't able to go to court for some reason, maybe they've tested positive for COVID-19 or live with someone who has, or even some of the court access restrictions. If you wake up that morning with a cough, they're not going to let you in. So apart from just sort of the normal impediments that a lot of people, especially people with low income face, to using the court system, remote hearings can actually be important for stopping some of these illegal displacements. To point out that one promising aspect of the CDC order is that it actually provides for criminal penalties, which we're urging should be interpreted to apply only to sort of egregious willful violations by landlords, not necessarily any time a landlord does anything wrong. But we think that could be a powerful deterrent for landlords to engage in self-help if that was a circumstance where a U.S. attorney would actually bring charges. by comparison to the CARES Act, the worst thing that would happen to a landlord if they filed an illegal case is that it would get dismissed. And a lot of times they're looking at a pretty modest filing fee, kind of a risk worth taking. A lot of them would, unfortunately. So the way that we've seen courts handle evictions during the COVID-19 era kind of breaks down into sort of three different categories. Unfortunately, a lot of courts, especially in certain states where maybe the leadership hasn't been as concerned about COVID-19 as other places, courts have just sort of charged ahead with hearing unlawful detainer cases and other types of civil cases, the same as before COVID-19. They may be taking some steps to spread out people inside the buildings and maybe test for people with showing symptoms at the door. But really, it's business as usual in a lot of courts. Sort of a more common approach, I would say, to courts that are still holding cases in hearing is in person, still holding hearings in person, is that the court will remain open for in-person hearings, but they will adopt fairly extensive requirements to limit the number of people who can be in the building at once, keep people a safe distance from each other, or at least what they believe to be a safe distance from each other while they're inside, require people to wear masks or sometimes face shields to limit the ability of people who may be infected to spread the transmission while they're in there. We've even seen some courts move to larger, more open air locations. I think probably the best known example of that is in Columbus, Ohio, where they opened the convention center and turned it into a big courtroom to hear evictions, which is not what we like to hear, because that enables them to go forward with the eviction tsunami. But at least they're taking some steps to keep people safe while they're doing it. And then, of course, many courts have shifted to on some type of remote hearing, whether that be by telephone or by Zoom or some other video conference platform. And there have been many of these sort of hybrid models where you may have some people present in a courtroom, other people participating remotely by phone or by remote hearing. Sometimes the court will have sort of a standard set of rules for this is how we're going to do it. And then a lot of times it's the courts coming up with a system for maybe each individual case based on how many people are participating. If it's a landlord-tenant case with a pro se landlord and a pro se tenant, and there's no witnesses, you may just have the parties appearing, even remotely, by phone or by video conference. If you've got something where you start to have witnesses, you start to have attorneys, start to have interpreters, other people participating, you may need something else to manage that. So which of these approaches is best? Our opinion, should be not having evictions at all. So we like to point out the flaws in all of these different approaches. There's really not a perfect one. And usually the lens that we look at these things through is the lens of due process. Of course, we've had summary proceedings since, I actually researched this recently in English common law cases. They date back to the Assize of Clarendon in 1176 AD, which was after the War of Roses in what's now the UK. There had been a bunch of competing noble or royal families, and they'd given each other lands when they were in power, and then they would be overthrown and somebody else would be in power and they give the same lands to some other group of nobles. And then after a while, you had all these different warring British noble families, each claiming ownership of the same lands. And the king had to figure out some way to sort these out without people resorting to blows. So they came up with basically borrowing the summary eviction proceeding from Roman law. So who knows how far it goes back in Roman law. But you would call the neighbors together to basically have an impromptu hearing and decide who is entitled to possession of the property at the current time. And then you could sort out the actual legal title ownership issues later in some more convoluted, complicated procedure. But that dates back more than 900 years, I guess, in the English common law countries, and of course has been adopted by every U.S. state. And so basically on the basic principle of we've always had this, and so how could it possibly violate the Constitution? The U.S. Supreme Court upheld summary eviction proceedings as basically consistent with the requirements of the 14th Amendment in the case of Lindsay v. Norman in 1972. Very minimal due process requirements for a summary eviction proceeding. You have a right to have an attorney if you can provide one on your own. You have a right to confront and cross-examine witnesses. You have a right to respond to evidence presented against you and present evidence of your own if it's relevant to the issues of the court. The Lindsay v. Norman case even held that it's permissible if courts want to separate out certain types of defenses. So for instance, if I don't know what the law is in Pennsylvania, but in some states, you can bring a habitability claim and seek a set off of your rent, say, the conditions were bad, so I shouldn't have to pay 100% of my rent. In other states, courts can require that you just do that on your own in a separate proceeding and that it doesn't relate to the right of possession. That's not a violation of the 14th Amendment for courts to do it in the latter method. Basically having a hearing before you're evicted, a pre-termination hearing, and of course an impartial decision maker and a decision on the merits. So these are the basic requirements. They're very rudimentary, very fundamental due process requirements. Yet I think we'll see that a lot of the hearings that are taking place during, especially the COVID-19 era, it's questionable whether these basic safeguards are being afforded. And I think it's also true that when we look at the due process the basic standards, I'm sure everyone listening on the line is at least familiar with the basic Mathews versus Eldridge requirements, where you look at the importance of the interest at stake, housing, basically how likely you are to improperly evict somebody based on the quality of the procedure you're using, and what could you be doing differently to improve the accuracy of the court's decision, and then the cost-benefit analysis that goes along with that. Mathews wasn't decided until 4 years after Lindsay v. Norman, but the principles were basically the same. However, Lindsay v. Norman and Mathews, for that matter, neither of those cases were decided during a pandemic. And so I think there's a very strong argument that under the current circumstances, the basic Mathews considerations are different. It's more important for people to have housing during a pandemic than it is not during a pandemic. Certainly very important not during a pandemic, but when people need an ability to distance themselves from others, to practice good hygiene and so forth, it's even more important that they be able to remain in their homes. The risk of erroneous deprivation, as we just saw, the complexity of the types of laws and both what those laws mean and the difficulties of being able to comply with them, the different procedural hoops, and even just being aware of what the laws are in your jurisdiction and being able to assert those defenses greatly increases the risk of somebody being improperly evicted during the COVID-19 era in comparison with the sort of pre-COVID era where these types of issues just didn't exist. You've got an increased value of property interest at stake, an increased risk of erroneous deprivation. That calls for greater procedural safeguards. And furthermore, there's a public interest here in enabling people to stay in their homes and practice social distancing and reduce the spread of COVID. Whereas normally the only government interest with an eviction case is really, trying to do it quickly and efficiently to make sure that landlords aren't taking things into their own hands. So I think there's really important due process considerations at stake when we get to hearings during the COVID-19 era, whether we're talking about in-person or remote. Now, with any kind of hearing that you're going to have during the COVID-19 era, especially if you're making fundamental changes in the way the court is operating and the location where the court is hearing cases, it raises a real possibility of there not being adequate notice to the parties. So if you're talking about electronic hearings, for instance, having notice of the time and date of your hearing and the platform and having the link and ability to join that, having notice of what the procedures are, so that you can prepare your documents or whatever you need to do, make sure that you have the right equipment and everything. It's important to keep in mind that a lot of jurisdictions that have gone to remote hearings really adopted their procedures and rules in haste. I think there's been enough time now that a lot of courts have been able to refine things and work through them. Especially earlier on in the COVID era, there was just a lot of aspects of remote hearings that courts had not thought through, and certainly hadn't provided guidance and made information available to the public and to court users on how these procedures were going to function. For courts that are still holding proceedings in person, a lot of courts have adopted very extensive restrictions on who can come into the building, under what circumstances. You have to bring a mask. You have to, what are you supposed to do if you wake up that morning with a fever, or you wake up that morning with a cough? Is there a number you can call? Can you get a continuance? What about witnesses? What if your witness can't come into the building? What if you show up to court and you weren't aware of the restrictions, or maybe you didn't realize that you had a temperature, and then they take your temperature at the court and decide that you're above the limit or something. What are the procedures? A lot of courts haven't thought through a lot of these things. In Virginia, where I'm currently active, a lot of the local courts have policies prohibiting people from bringing smartphones into the court, which is a problem already, because a lot of times people have things like text messages and other evidence they want to present to the court on their smartphone and then show up to court and they can't bring it in. But because of that, a lot of times people aren't aware of that rule. They leave their smartphone at home. And then if they go to court and they're not allowed in the building because of one of the COVID restrictions, they're asked, you've lived with somebody who's traveled out of state within the last 2 weeks, and they answer yes, and they're so you can't come in. And they don't have their smartphone. So even if there's a number to call, they don't have an ability to actually make that call. So a lot of these procedures can really wind up impairing somebody's ability to appear and defend in their case. And then a lot of courts that have had remote hearings available may not publicize how to get a remote hearing, how to request a remote hearing. And so you may have people who are kind of deterred from going to court, or maybe they know they're not going to get into the building, or maybe they don't have COVID themselves. They don't believe that they're a risk of transmission, but maybe they're in a high risk category. If they were to become infected themselves, they might be at the highest risk of having a really severe case, and they're just deterred from going, and they don't know that there's a remote hearing available that they could request. So notice is certainly a key area to look for due process violations that may prevent courts from being able to lawfully go ahead with eviction hearings during the COVID era. Of course, this idea of people being chilled from going to court because of the concern that they may be infected, that can certainly be exacerbated in communities where maybe the court is not either they haven't adopted adequate social distancing rules for the court, or maybe they've adopted a policy that on paper looks like it will keep people safe, but it's not being enforced. So, people are still congregating in large numbers inside hallways and lobbies and security lines, and nobody does anything about it. That can chill people from going to court, even if there's a written policy saying that shouldn't happen. Certainly in communities where people have to rely on public transportation, or even for tenants who would get to court by taking a bus or having to wait at a crowded subway stop. Again, these are things that can chill people from going to court, and not just the parties themselves, but it could prevent witnesses from being willing to show up, for instance. In cases where people have a right to a jury trial, a lot of times jury trials are just not being held right now. I think a few courts have experimented with having jury trials by Zoom, but I'm not sure how well that's gone. And I think it's really just been limited to a few cases. I don't think that's really caught on. It's been a national trend, at least so far. Of course, having the public being able to attend and observe how cases are going is important, not only for the public's right to oversee how the courts are functioning, publicize any improper conduct that they may observe. But the fact that the public would be there and be in a position to do that is one of the things that's supposed to keep courts and judges honest. And so if the public is either excluded entirely, or just doesn't have any real practical means of attending the hearing, especially over time, I think there's that can start to erode the court's awareness of the public's there to observe. So if the court's not taking adequate steps to make sure that the public has access, then that I think raises due process concerns as well as sort of open courts to concerns. So moving on to what we've seen with remote hearings so far. As I mentioned, there are some benefits of remote hearings. They really do solve some of the problems that we've just seen, especially with, for instance, the one I just mentioned with people that are chilled from going to court by the risk of infection. If they don't have to leave their home, if they can sit down in front of a computer screen and participate in a court hearing, that removes that danger. There's even benefits in remote hearings, I think, for reasons unrelated to COVID. In a lot of more rural communities, especially where it may be difficult, cost burdensome for people to actually be able to travel to court. This brings the law to them. They don't have to leave their home. They don't have to maybe spend money on gasoline that is going to be burdensome for them, or try to get a ride from a neighbor or something like that. So there can certainly be some benefits with remote hearings, not just for eviction cases during COVID-19, but for any types of proceedings. But on the other hand, they also present their own set of challenges, so they are not a perfect solution by any means. So,
Eric, I'm sorry, this is Kelly. If I could just announce that I'm launching the first of the CLE poll boxes. You'll have about a minute and a half to respond to this. You must respond to both in order to receive your CLE credit for this session, and this is the first of 2. And Eric, please feel free to continue when you're ready. Sorry to interrupt.
Not a problem. So there's a few different kind of threshold type questions with different remote hearing regimes that courts have adopted. The first is, are the remote hearings going to be by consent, basically meaning that both parties have to agree to have the hearing remotely, or else it can't happen? Or are they in some way mandatory, where basically the court's going to have a hearing, and if you want to defend yourself, you need to participate in the remote setting. Of course, we have a strong preference for courts doing this by consent. And for instance, in Michigan, I don't know if this is still the case, but earlier in the summer when they first started with remote hearings, both parties had to consent. And so obviously, if you're a tenant facing eviction and you don't consent and the court's not holding in-person hearings, then you couldn't be evicted. So I think that's, I guess, probably the main pushback or the main objection that I think we see courts and, of course, landlords having to adopting a consent sort of approach, that people will just, even if they don't have any technology barriers or other reasons not to participate in the hearing remotely, they will do it just for purposes of delay. And when we're facing a massive eviction wave of more than 20 million evictions, and that would have just incredibly destabilizing and harmful effects on communities, you know, that delay is nothing to shake a stick at. But unfortunately, I think a lot of courts are becoming increasingly resistant to giving parties the sort of unfettered ability to decline to consent to a remote hearing. I think where this is likely to remain in these sort of consent regimes remain more common is with sort of the more general civil litigation, where especially both parties are represented by counsel, and there's not a clear benefit of delay for either side. But certainly where the court makes consent of both parties a condition, or at least consent of the tenant a condition of having a remote hearing, you know, I see nothing wrong with taking advantage of that and saying and declining to consent to it, assuming, of course, that means that the court's not just going to hold the hearing in person. If that's the case, then you really do need to make a decision of, you know, whether your client's interests are better served by having the hearing remotely or having the hearing in person. That's probably going to depend on each particular case. Then in terms of how are the remote hearings held, are they audio only telephonic hearings, or is the court holding video hearings? You may, if you've been in any previous presentations I've given or seen materials I may have put out previously this year, I had originally taken the position I didn't think telephonic hearings were really acceptable at all without consent of both parties. I think may have softened on that position a little bit, at least for hearings where all the court is doing is maybe scheduling some future hearing on some future evidentiary hearing or something, or possibly where there's, say, a motion and you're just having arguments of counsel. There's no witness that's going to be examined. There's no documents or exhibits that people need to see. But really, as we saw above, one of the few core due process rights that tenants have in an eviction hearing under the 14th Amendment is a right to confront and cross-examine opposing witnesses. And you certainly can't confront somebody, in my opinion, on the phone. I think that involves the ability to see the witness in person, to see what's happening. Furthermore, you know, one of the real concerns with an audio-only hearing is you don't necessarily know where the person is, who else might be in the room beside them, that sort of thing. You know, what other types of things may be influenced. witnesses' testimony. So um, I would say, at least in my opinion, telephonic hearings generally not appropriate for any kind of evidentiary hearing. They may be appropriate for hearings less than that. But really, video conference hearing should be the preferred approach to remote hearings. One challenge that video conference hearings do present is that they are somewhat less accessible. They require a higher degree of not only they require more and more sophisticated equipment, but they require a higher degree of sophistication on the part of the user. So you need participants to actually have the ability to use the video technology, which most people can use a phone. Video conference, I think a lot fewer people can use that. So that is a challenge, but as we'll see in upcoming slides, I think the burden really should be on the court to make sure that people have access to that technology if they're going to proceed with hearings. If they're not able to do that, then they shouldn't have the hearings. But of course, the benefit with video conference hearings is that they do provide some ability to see what's going on, to guard against some of these problems, such as maybe somebody being in the room right next to the witness who's testifying on the phone, and witness's testimony is influenced by that person's presence. Certainly you have some ability to actually see physical exhibits and documents with a video conference hearing that you may not have with a remote hearing. So despite some of the increased complexity and opportunity for technological problems, generally speaking, of course, we're going to be holding evidentiary type hearings remotely. They need to be doing it. But, slides are freezing again here. There it is. Okay, so of course, lots of people, especially lower income people, may not have high quality computers with modern processors and high-speed internet connections that they can use to get on a Zoom call and have their hearing with a functioning video camera and microphone. A lot of people rely on smartphones. A lot of people have older devices that may not have a video camera. A lot of people are using damaged devices, so it may have come with a video camera when they got the phone, but it doesn't work anymore, and they don't have the ability to replace it. A lot of tenants may not have access to high-speed internet connections. A lot of people may rely on things like libraries and coffee shops to get on to get access to high-speed internet, and those facilities are either not open or just not practical for to connect with a court hearing, for example. And so this is one thing that courts definitely need to account for when they're going to be providing video online hearings. And so how can they do that? There have been a number of different approaches that courts have taken, some better than others. Sort of at the outset, it's kind of incredulous to see that a lot of courts thought it was sufficient just to provide a room at the courthouse with a terminal. They had a microphone and camera, and the person could log in and use the computer there at the courthouse. Because the whole point of having a remote hearing is so that people don't have to go to the courthouse. So that doesn't really solve the problem. And I think the response as well, that they'll be in a room by themselves, and people will be socially distanced, and so they won't have the same kind of risks. Really, it doesn't get at the heart of the problem that people are having to leave their homes, often take public transportation where they may be exposed to risks, go through a security line where they may be exposed to others, still be in an indoor facility for lengthy periods of time. I think this is still the approach that some courts are taking. In my opinion, it's not adequate. A sort of step beyond that, in some jurisdictions, courts would create a Wi-Fi hotspot somewhere in the court facility, and then they would have tablet computers or Chromebooks available that people could kind of check out, and then they could go find a place nearby that was within range of the hotspot, and they could use that. There was one court, I think in Idaho, this summer that was providing the hotspot in their lobby, and then people could go outdoors, areas near the courthouse, and I guess sit at a park bench or something and use the tablet there. I haven't been able to speak with anybody who experienced that sort of procedure or when could say what that was like, but really seems questionable that you wouldn't have kind of a quiet environment, in which to concentrate on the proceedings. Some of these Wi-Fi hotspots, I really question the range, how far they really go, and how good would these connections be. But at least that's better, I think, than some sort of indoor dedicated terminal. But really, I think the main benefit is the court recognizing that they needed to provide multiple devices that people can use as needed. Some courts are doing what I consider the best practice. If somebody doesn't have their own device that they can use to participate, then the court will send a marshal or a sheriff's deputy or some appropriate official will go to the tenant's house and create a Wi-Fi hotspot with a smartphone or whatever they use at that location, and provide the person a mobile device that they can use to participate in the hearing at that time. So I think some people have, legitimately raised questions about, well, then you've got to have people allowing, law enforcement officials, court officials into their homes, and that can make people uncomfortable. That can create problems, and that's certainly true. But I think in terms of providing meaningful remote access to judicial proceedings, that is what courts should be doing, or at least offering to do. Is sending somebody out to the home with the necessary equipment that person can use. So, when video hearings start, I think a couple of often overlooked basic things courts can do to ensure, fairness and I guess get the best out of the proceeding. One is, requiring that people who are participating in these remote hearings from their homes are alone in a room with the door closed, and they have the person pan around with the camera to make sure there's nobody else in there, and so forth. Because again, one of the main risks with a telephonic hearing is that somebody's testimony might be influenced by who else is around. And are they going to hear what the person is testifying to, and how are they going to react? You don't want the same thing happening with the video hearing. So courts should be taking steps to make sure that people are isolated. It's helpful if people, if their testimony is not colored by, or their credibility is not colored by maybe other things in the background. I realize I'm not exactly following that rule myself here this morning, but ideally you would want to have, a plain or neutral background, so a blank wall, or maybe something, something that doesn't say "crush fast" in Spanish on it. But you never know what might be in somebody's background on a Zoom call. I think that's an important practice tip. For tenants who are going to be appearing from their homes, make sure they don't have anything that might put them in a bad light in front of the court, or that might prejudice them negatively in some way. I've often thought too, is there any sort of prejudice that might occur in the other direction if somebody has something irrelevant in their background that might make them look more credible than shouldn't. I don't know if you had a law office where the lawyer has all of his, lawyer of the year trophies, or we have a witness with, who's maybe a military veteran and has, a bunch of military medals and things hanging up in the background. It seems like, there could be a risk of unfair prejudice the other direction too. I haven't really seen any of the there are now many different court guides and best practice documents in remote hearings. I haven't seen any of them address that. I think that's another thing to be on the watch out for as an attorney. Last, it's important that when courts are having the parties appear remotely, I think especially at the beginning, some courts would, they would log on and it's the court's personal chat room, and as soon as the hearing is over, everything shuts off. Sometimes there's a need for sort of sidebar conversations that attorneys and clients can communicate with each other confidentially, and using some of the breakout room type features with Zoom or other similar platforms. So courts, should be providing for that. Although personally, I think it's best to make arrangements with clients to communicate through a separate device, so that you're not relying on the court not to mess that up. Or if there's some kind of mistake and the breakout room winds up, they put someone in there who shouldn't be or something. There's not a break in confidentiality. But these are pretty basic things, I think, that are often overlooked. So keep those in mind if you deal with remote hearings. The question of how to deal with exhibits is probably the most elusive, difficult remote hearings question that courts face. I think it's not a big problem when parties are represented by counsel. You have a lawyer on each side. It's easy for them to use different types of approaches that courts have come up with so far for managing documents. Particularly when you have a large number of documents, or maybe a large number of potential documents, you don't necessarily know which things are going to be necessary or not. Where these documents may have a lot of pages, and you can't necessarily predict, which paragraph of the 30-page lease is going to be relevant to the case. Really the only practical option is either to have everybody upload these documents into some kind of common folder, Dropbox, or or the storage cloud type things, Google Drive, ahead of the hearing, excuse me, and then have that available. Then have that folder available to pull the documents out of during the hearing and display as needed. Or email those documents to the court. The court can manage the documents however it wants to do it and make them available. Of course, using these types of approaches can be very difficult for tenants who don't have counsel. Most tenants are not going to have access to document scanners or document feeders, and they can easily copy a 30-page lease, for instance, and upload it to a Dropbox. If you've got other, numerous documents that are difficult to deal with, rent receipts, and things that have been through the washing machine and so forth, it can be really difficult for tenants to comply with those types of procedures. When the parties have counsel, there's even actually dedicated software programs that are sometimes used for trials, even if they're in-person trials, where they upload all the documents onto a platform, and then they give everybody an iPad so they can look at the documents on the iPad instead of having all the paper. So, again, when counsel's involved, these things can be very sophisticated, and sharing documents the attorney should be able to work through the kinks, preferably ahead of time. But for unrepresented tenants especially, these can pose real challenges. Screen share, I think a lot of times can be, some versions of some of these platforms may not even have that available, or it may not work with a particular device that somebody has. I've heard stories of judges instructing people to just point their camera at a document and then try to read it on the screen. I really question how well that sort of thing works. I think that the best practice document I've come across on this is one from the American Bar Association, and even they sort of acknowledge that there's not really a perfect solution here. But basically, still using kind of a common file Dropbox type approach, but providing the technology for tenants to be able to go somewhere and have their documents uploaded. Ideally, having somebody at the court who can assist with doing that. Providing detailed instructional videos, not just written instructions, but YouTube videos showing people how to actually do these things. Without which I probably wouldn't be able to ever fix anything in my house. And then the ABA also recommends giving pro se litigants the opportunity to do what they call a dry run, basically practice with the technology ahead of time before the hearing, so that they can figure out how to use it and have a chance to ask questions. But this is a real challenge with tenants who are unrepresented being able to present documents to the court. I guess this probably belonged on its own slide, but whenever you have remote hearings, there's always a possibility somebody may not show up for the hearing, and you don't know whether that's because they decided not to appear, or because maybe they were in an accident or something, and couldn't get home in time to log on or something, or if they're just having some kind of tech problem, they're not able to connect. The California Access to Justice Commission issued a best practice guide where they recommend that courts use practice reluctance to punish litigants for not appearing on time, however they phrased it, was practice reluctance. I think that's really a best practice for courts, that if somebody doesn't appear, I've heard horror stories of courts that will just default the person the same as if they didn't show up for an in-person hearing, when they very well could be having a problem with connection. So at the very least, I think courts should make some effort to make sure that the person's not, they click the wrong link, or they're having a computer problem. They try calling them on the phone, have some type of way that if the person's experiencing a technical problem, that they have someone to call, report the problem with, and they can email someone, do something before just entering a default order or a judgment against the person. Unfortunately, I think a lot of courts differ with that. So already I've noticed a lot of judges have found that it's difficult to judge the credibility of witnesses by remote hearings. I think this one in particular, when you've got a witness not only on a computer screen, but then has a large mask covering the witness's face. I guess personally, I've always questioned the extent to which things like facial expressions and body language are that important to judging credibility, but I think a lot of judges will say that it is. And for this reason, I actually had a trial scheduled for this summer. It was supposed to take place in U.S. District Court, and the judge moved it to February, saying, "I'm just not confident in my ability to assess witness credibility." And I think a lot of courts on a computer screen, even without masks. So I think this remains a viable due process argument, even if you have a remote proceeding, even if you have people appearing in their homes where they don't need to cover their face. Judges may well be receptive to an argument that this is not sufficient for evidentiary dispute. But I think some judges are probably going to find that it is, and they just depend on each judge. But I think certainly, where facts turn on sort of, where somebody's accused of lying, or sort of the he said, she said type cases, you may find the most traction those types of arguments. Another real challenge for courts in remote hearings has been making sure that adequate interpretation is provided for participants who are limited English proficient. One of the big reasons is that in-person court hearings, normally when there's language interpretation, it is done through simultaneous interpretation. So you'll usually have the interpreter standing very close to the LEP participant, basically providing simultaneous interpretation of whatever is being said. And that's really not possible in the remote hearing setting. Instead, interpreters need to use the consecutive interpretation technique, which is, you're probably familiar with this from when you speak with clients or LAP on the phone and you have an interpreter being provided through a language line type program. So you might say something and then the interpreter will interpret that to your client, and then the client will hear that and then say something back, and then the interpreter will interpret that back to the advocate. This takes a lot longer than the simultaneous interpretation that courts are used to. And so that's an adjustment for courts to handle. I don't know how many courts are doing this, but I heard earlier this summer that some had come up with a system where they would have an interpreter place a separate telephone call to the LEP participant. So you would have a video hearing, say on Zoom, where the LEP participant, might be a party, might be a witness, would be on the Zoom, and then would also have a separate telephone call with the interpreter. And so the interpreter would be expected to be providing the simultaneous interpretation to that person while the Zoom conference is going on. I think that's a really terrible idea, and so do the language access experts I discussed that idea with. I mean, one main reason is that it really doesn't allow participants to hear everything that's being said. And then I think that really the big problem that language access experts pointed out is that it doesn't enable the court to make sure it's pausing as appropriate to allow the consecutive interpretation. It's really, in fact, it's designed to provide sort of a substitute for simultaneous interpretation. That's just not possible. So if courts are planning on using that system, and you have clients or witnesses who need interpretation, I would urge you to object to that and insist that the court use the consecutive interpretation method. And I think you'll be able to find multiple language access guides for remote hearing practices that urge that approach. What I just described, much of it was from the Washington State Language Access Commission's best practice guide. Similarly, in an in-person hearing, a lot of times interpreters are needed not only to interpret the actual court proceedings themselves, but then also some of the conversations that take place between attorneys and their clients before and after the hearing, or sometimes during breaks in the proceeding. And this again is something that the court's breakout group function should be available for. If the Zoom connection just terminates at the end of the hearing and there's no ability for the LAP person to have the interpreter available to and have their attorney explain what just happened, they're not really getting the full benefit of the language access services that the court is attempting to provide and should be providing. Last, sign language interpretation is not compatible at all with audio only formats. So you need to use some kind of video hearing for people that need sign language interpretation. The best practices are for courts to consult with or contact the person who needs the sign language services and figure out what works best for them. And it may require particular types of technology or particular types of software to accommodate the ASL interpretation. I mentioned earlier the importance of enabling the public to attend and see what goes on at hearings, even if they're being held remotely, and that's for the benefit not only of the public, but also the participants in the hearing. Courts basically have adopted 3 approaches for doing that. One is to just stream the hearings live on YouTube or whatever other platform. Another is to record the hearings and then upload the recording after the fact to platforms such as YouTube or some other type of video sharing website. And then the third approach is to basically give out the sign-in information to the public. So members of the public who are interested in seeing a particular hearing can join. I will say the Kansas City Tenants Union shut down hearings in Kansas City for a day by basically having people join the Zoom links and then disrupt the hearings. And so I think for that reason, courts have started to shy away from that approach. But I think that's unfortunate. I think that's really probably the best way to provide public access. I think they do have ways of muting people who are disruptive. Not that I want them to figure that out, but one best practice guide I saw on how to provide public access. I forget where I got this one. I should have cited the source, but basically they recommend providing detailed notice to the public and how they can access hearings, where they're going to be and how to find them. Publishing a daily docket so members of the public can see what cases are being heard that day and how to access them. And then also it's important that if the public is going to have access to these hearings, that people who are participating in these hearings are aware of that and can take steps to protect their privacy. So for instance, if you're joining a hearing by phone and your phone number is going to come up on the screen, you may not want the whole world to see your phone number, so you can change that to your name or your initials or something so it doesn't appear. Or you may not want people to, may not want the whole world to see what the inside of your house looks like and so forth. So, but unfortunately, I think there may still be some courts that are not really taking steps to enable the public to have access to the hearings in a meaningful way. And if that happens, I think that's another not only due process violation, but potentially an open courts type violation that you may be able to assert to at least slow down or stop evictions from taking place.
Eric, you mentioned best practices there. We did have one comment or one question wondering if we're aware of any good examples for instructional videos for pro se litigants for remote hearings. I'm not familiar with any instructional videos or materials that have been provided for pro se litigants in particular. Here in Pennsylvania, there may be that I've just missed. Are you in any of the best practice guides that you've seen, Eric? Have you seen anything that's been geared towards the pro se litigant as opposed to the advocate?
That's a good question. Most of what I've seen for that has been at a very high level. So it will be guides such as telling people try to log in early, to make sure their equipment's working and everything before the case is called. Make sure that they have, a background that they're satisfied with, that's not going to be distracting. If they're using a phone, make sure their battery's fully charged, things like that. I think the difficulty in any sort of generalized guide for pro se's like that is, because each court may have its own local procedures and practices, it's probably best if those come from local advocates. But that's a good question. I wish I had one that I thought was good that I could recommend.
Yeah. And one thing that I'll say in answering that is, while I'm thinking about it before I forget it, kind of as a plug for later this week, this coming Friday, October 9th, from 2 to 3 p.m., we will have individuals from Temple's Beasley Law School. Sarah Katz and Liz Lippy will be presenting a session on best practices for remote hearings. I do believe that that's going to be geared more towards advocates, of course, but they may have some resources that they turn the audience onto for pro se litigants as well.
Great. So we're getting to the end here. I just want to say the National Center for State Courts has, they came right on and said earlier this year, look, there's just some types of hearings that, the remote procedures really are just not adequate for, where you can't have a proper connection. I think that's pretty obvious. But when you have a lot of documents involved, I'm not sure what they mean by some complex subject matter, but issues of witness credibility. Again, the document management challenges, especially for pro se's, are really difficult. And if the court, just can't overcome that, then the court should just acknowledge that they cannot afford due process in the current environment, and they just are going to have to wait. And the same thing with witness credibility. So I would encourage folks to continue making these objections. Don't just accept the fact that the court's going to go forward with hearings, even if there's serious problems with fairness. Just a couple last thoughts on hearings during COVID-19. I mean, there's outside of the courtroom, COVID-19 can present some real barriers to people preparing for their cases, especially in eviction hearings where you often either don't have any formal discovery procedures at all, or if you do, they're very limited. People really need to rely on informal investigation, being able to get documents from government offices, businesses, and things, and those sources may be closed. They may be operating on limited capacity, may not be providing the kinds of services they normally do. They may be out of business and not, the records may have, may not be available and so forth. So, that's another due process issue in these cases, regardless of whether the court will hear the case live or in person or in a remote form. COVID can deter people's ability to go and seek help from legal aid programs, seek other kinds of assistance in preparing for their cases from other types of programs if they're not functioning, if they're at reduced capacity, and so forth. I think there's a decent argument that with the increased complexity of these cases, the increased stakes involved, especially if there's procedural problems with remote hearings and so forth that people are not accustomed to, if they have technological barriers, arguably, at least for some tenants, there may be a right to have the court appoint them counsel if they haven't been able to obtain it on their own. I think at the very least, giving people an expanded opportunity to go and seek help from different legal aid programs and other resources that are available. So that may mean continuances and so forth. I think even courts that are not holding remote hearings generally need to have them available as reasonable accommodations for people who are, say, in higher risk categories and unwilling to leave their homes. So I think I know, Matt, I think there was someone.
Yeah, if I can, I'll interject, Eric. So I just, for my purposes right here in Dauphin County and Perry counties, where I operate, I have not seen the use of remote hearings in magisterial district courts. I have talked with colleagues who are in the courts of common pleas frequently, especially with family law cases. In the common pleas courts, we have seen the use of advanced communication technology. Like, for instance, here in Dauphin County, they utilize the Windstream platform. From what I've heard from my colleagues, those hearings, now, mind you, these are in, I think, almost every situation or every case, we have, parties who are represented by counsel on both sides. But in those instances, they've actually found the setup to be quite effective and useful as far as getting everybody together with the judge. If they needed to, sidebar, say, and have a communication with their client, they'd be separated out into a separate room. But I've not seen that at the magisterial district court level. Our local order in Dauphin County, when we opened up back in mid-June, our local court order actually had required the use of advanced communication technologies wherever possible. That said, in talking with our court, it was made known to me pretty early on that they, for various reasons, they didn't feel that they were ever going to be able to get that up and running, between trying to get the actual technology out to the judges' offices, trying to get the judges and their staffs up to speed with utilizing those technologies, and then trying to make, like you had mentioned earlier about a terminal, Eric, like at the courthouse, like trying to make a terminal available, and would that be practicable for the MDJs or their staff to be able to assist individuals coming in for hearings if needed. And so basically what we've been doing, and I think this is likely to be the case, is despite the order, everything is just going back to in-person hearings. They have utilized some additional protections as far as spacing out hearings and not holding the quote-unquote cattle call hearings where we have large groups of people all joining at once. So they've spaced out hearings, but I think by and large, I've only heard of one through the grapevine that was scheduled in one of our MDJ's offices, but I personally haven't seen one. Now, that said, I do have on the call here with us a colleague of mine, Susan Mahalik, who participated in and then talked with the client in Huntingdon County, which is one of the more rural areas in the central part of the state. So Susan, I'm going to ask you to unmute here if you can, to share with us quickly your experiences.
Sure. First of all, the first one I had, there was 7 people on the Zoom on 6 different devices. Huntingdon County is very rural, and then within the rural county, we have patches of very ruralness, and the landlord and the tenant were in the same little patch of this very ruralness. So I was amazed that we all stayed on the Zoom. That case was dismissed because the landlord didn't give notice. My second observation was that a landlord-tenant hearing was scheduled by Zoom. Everybody appeared to be on it. However, the client couldn't hear anybody. The judge apparently couldn't hear anybody because he kept putting his hand behind his ear. So the judgment was entered against client. She contacted us, and I filed an appeal just to let her have her say in court.
Thanks, Susan. So yeah, I know, again, a lot of the things that you've been mentioning, Eric, I think in especially when we're talking about at the magisterial district court level, where we're dealing with, again, elected officials who might not be as keyed into the legal ramifications as say common pleas judges would be. I think that's where we're more apt to see these problems crop up, as Susan had mentioned there. I mean, it's not like Susan had mentioned the one that actually worked out appropriately, but the other one where the judge just simply couldn't hear the parties, just decided to go ahead and enter a judgment anyway, which I think is the fear in many of these. So I'll turn it back over to you, Eric. Thanks.
Actually, this is Kelly. I'm just going to jump in quick and launch the second CLE box poll. Attorneys, you need to respond to this and the one that was already launched in order to receive credit. And Eric, please continue. Thanks.
So I went a little bit longer on my slides than I expected. So I know we've only got a few minutes left. I can either have a couple more slides that I can get to, or I can just take questions. So whichever you prefer.
I mean, again, we only had that one question, Eric, that we hit on.
Okay.
So I think that if you want to just kind of roll through them and hit the key ones that you want to hit in the couple minutes that we have, and then we'll see if we have any other questions between now and then. That works.
Okay, so I just wanted to point out, some of the remaining protections. I think it's important to keep in mind that the CARES Act is still U.S. law. We had expected that there would be additional legislation that would change this, but it didn't happen, which is not overall a good thing, but it does keep the 30-day notice requirement that applies in the CARES Act in effect. So any covered property, any property that's covered by the CARES Act is still required to give 30 days notice before they can terminate a tenancy. I think that's something that a lot of landlords are likely to overlook. I hope no tenant attorneys will overlook that. There's also some additional protections that may not really reach very many people. It may be hard to find out about, but there are still properties that are multifamily properties able to receive forbearances that were either authorized by the CARES Act or different regulatory measures. And the condition of those is they may not evict tenants. So the government was supposed to prepare a database that you could look up these multifamily properties that have received forbearances. They said they were going to do it, but I haven't been able to find it, and I don't think they actually did it. So that may or may not be forthcoming. They did require that anyone who receives a forbearance give out notice to tenants, but I think they will probably send out one letter, and tenants may not have it. But that's another thing to check. If someone's being evicted from a multifamily property that has any kind of federal financing, they may have gotten the forbearance, and if so, the tenant may have an eviction protection under that. Well, I think we're just about.
I was going to say, we did get one other question there now that I see
Okay.
you getting into the CDC eviction restrictions. We were wondering if you had seen or heard any instances where a U.S. Attorney's Office or the Department of Justice had taken on a case, whether it be a landlord violator or a tenant violator of the CDC order.
No, I have not heard of any. I think we're still waiting for that to happen. I think it would really send a message to some of the real, the landlords that are willing to do whatever to get somebody on their property if somebody were to be prosecuted for a violation of the order. So I hope that happens sooner or later, but to date, I'm not aware of.
And I guess the last thing I'd ask real quick, if there's any kind of like brief update synopsis you can give in like a minute, right, is I know that we had some concerns early on that the order would be challenged in some fashion. And I know that there have been a couple of cases filed, but are you able to give a kind of a brief synopsis as to, do we feel that there is a viable challenge pending that we might have this CDC order come overturned anytime soon, or do we think it might actually last until the end of the year?
So there have been 3 cases filed in different U.S. district courts challenging the order. The first one was filed in Atlanta and is set for what's on a briefing schedule. There was a motion for a preliminary injunction filed. The government filed its response on Friday, and then I assume the plaintiffs will get an opportunity to file a reply to that, and then the court will have some kind of a hearing. There was a case filed in Tennessee where there was no actual motion for any preliminary injunctive relief until the week before last, and we're still waiting on some kind of briefing schedule to be entered in that case. But the one to really watch is the one in Ohio. This was the last of the 3 to be filed. But on September 23rd, the judge in that case announced that he was going to hold a hearing on the motion for a temporary restraining order on the 25th, which he did. So the DOJ appeared, and there was a telephonic hearing on the 25th, and the judge denied the temporary restraining order. Unfortunately, he then asked the parties if they thought there were any discovery issues or factual issues that needed to be sorted out, and the DOJ said no. And that enabled the judge to consolidate the preliminary injunction motion with the trial on the merits for October 15th. So that means that instead of a preliminary injunction hearing where the fact that there's a huge public interest weighing against entry of the relief and that there's no non-economic irreparable harm at stake would seemingly be grounds to deny it, it's probably going to be heard on the merits, and if the judge rules in the plaintiff's favor, could be a permanent injunction, not a preliminary injunction, and may strike the order down nationwide, in which case, hopefully the DOJ would quickly appeal to the Sixth Circuit and seek a stay of the injunction, but we'll see how committed they are to defending it. So there's reasons to be nervous right now, but we'll see.
All right, great. I think, Kelly, we're probably about out of time here. And so thank you, Eric. Thank you very much for sharing this information, your expertise with us. And thank you for all the participants. As I'd indicated in the chat, I will be getting the slides from Eric and perhaps pulling together some other materials, and we'll make them available on the Sketch app within the next day or two.
Thanks, everyone.
Any other housekeeping issues, Kelly? Otherwise, thank you all. And again, just another quick plug, just as a follow-up session this coming Friday from 2 to 3, a best practices session for dealing with remote hearings. If there aren't any kind of challenges that we discussed today, then there isn't a way to get rid of a remote hearing. And like, as you said, Eric, the best case would be to have none, right? No hearings at all. But if we can't work around them and you do have a remote hearing upcoming, then Sarah and Liz from Temple will be talking with you all about how to prepare for best practices in the event that you have to attend a remote hearing this coming Friday. So,
Okay, thanks everyone. Take care.
thank you. Take care. Thanks again, Eric.